going to be part of this case, then we should be able to arraign you right now.
We should be able to. I'm not arguing for that. We're not arraigned if you haven't been indicted.
All right.
Right, let's go on the record in the matter of the state of Arizona versus CR 202510 defense motion to represent himself, defense motion to represent and the status conference, part of the status conference, parties
Rachel
appearance.
Stiles for the state. Rachel Stiles for the state.
This is William Parham. Mr. Myers, something came up. We need to address. Mr. Myers, something came up. We need to.
Okay, I want to address something else. Okay, I want to address something else. First of all, the first thing I'm going to announce is streaming. But then I want to address. Request of the Joey Payne of the Phoenix Times. To have cameras in the courtroom. I was under the impression when this was from the Phoenix New Times, and that's how I identified it yesterday. Maybe I didn't read it close enough. And then yesterday during the hearing, Mr. Myers had said that he owns this. I looked up the Phoenix Times. There is a website called the Phoenix Times. It basically links to other news articles and posts press releases. I couldn't find any Joey Payne associated with that. And our public affairs representative indicated that the person here today is from RP Media, which is a different company. So I'm not at all certain who's actually making the request. And without that, I'm going to have a hard time to stream this. So Mr. Parvin, I'll start with you first. Your position on this.
Well, my position is, again, we've already ruled because there's no victims, or the court ruled because no victims here, there are less concerns. There's no objection to streaming. I think the court already prohibited Mr. Myers from using his own personal device today, under the understanding that others would be able to do it that would not have as much of an interest, I guess, in the case. Mr. Myers was allowed to speak on his behalf, even though I have not officially withdrawn yet. Could the court let Mr. Myers answer this question?
Okay, Mr. Myers, do you want to answer this?
The question, yes. Phoenix Times is a DBA. It's just a website name to, you know what I mean, do.
Yeah, it's owned by, hold on, it's owned by Newsmatics Inc., is that correct?
It's
in Washington, D.C.?
You pay them to host the website.
Okay.
That's who hosts the website.
Okay.
It's just to do ads and stuff so that you have a website people can go to and stuff like that. And because it's out of Phoenix, they had a local guy. It's just like having an independent contractor.
Okay, but I don't really know who this is, and I evaluate
who's here today or in general?
In general, who the Phoenix Times? I don't, I have to evaluate.
Media company.
It's your media company?
I own Freedom Productions LLC.
Okay,
and DBAs.
All right, so this is your company basically.
It's a DBA, but it's not an LLC.
Okay.
You don't have to have it registered to use it. It's so that we.
But your company basically opened this website as the Phoenix Times.
My company, Freedom Productions.
Yeah.
Which is multiple companies under it. Started that website so people had a website to go to, and we could sell ads so that we could have the email Phoenix Times and all that. In exchange for that, that company puts you out there, and then they run those ads on there, and they get ad revenue.
Okay. All right. Let me.
We do the stories and that kind of thing, but it's just like a website hosting thing. You know what I'm trying to say? You pay them to market you.
All right. Let me hear from the state. Ms. Stiles, your position.
So who do we have here today?
Somebody who says they're from RP Media, which my understanding is a contractor that has been contacted by somebody to cover this. The Phoenix Times is not an entity. My understanding is just a website that the defendant opened.
Well, the rule's just very clear that there has to be that notice given to the court prior to. So if we're getting somebody else who's filming who didn't provide the notice to the court, they wouldn't be entitled. We're still live streaming, so the recording's still being put out in the public. But if this isn't the person who requested this company isn't the one that requested the permission, then I think under the rule they're automatically denied. It's my understanding from the rule.
I'm going to reverse my ruling from yesterday. This is not what I thought I was approving, and I find it very confusing.
Can I say one last thing, sir?
Yeah.
Even though I'm not to persuade you to overturn it, but just to clarify something.
Make your record.
Yes. Yeah.
Go ahead.
Okay. Is there a better way you want us to file that in the future? Because it's ultimately Freedom Productions doesn't have its own website to give you.
Okay. You can file something. I'm not going to give you legal advice. I just did not understand who was making the request, and it was very confusing to me. And I'm concerned about the nature of the charges in this being a harassment case, about who's doing what. So I'm not going to allow. I'm going to deny that for today's hearing.
Can I say something, Your Honor?
Yeah, hold on. There were a couple of things I had on my list here before we.
Okay, but I wanted to add to that could change the prior ruling, maybe the reason for as well. Your Honor, we still believe that under the 122H, Mr. Myers should at least be able to use his personal audio recorder to record the hearing for his own purpose. I think that's what the rule permits. The reason we didn't object more at the last hearing is because the court was going to allow a separate company to essentially film this. We would have concentrated more on that objection and perhaps Mr. Myers would have filed more on why 122H would allow him to do audio recording today. That's a concern because the only reason we accepted the court's ruling without further argument, or Mr. Myers would have filed more motions, was that he understood the court was going to allow some sort of video today. I don't know what YouTube is showing. I don't know where it's being live streamed, how people can access. I'm just not familiar with it. But I think Mr. Myers at least would like to use his personal recorder 122H to give notice about it and be able to record this hearing.
I deny that. So let's. One thing I want to do quickly so I don't forget is Mr. Myers filed a motion to exceed the page limit, which I'm granting. That's for his anti-SLAPP motion. So
thank you, sir.
You didn't have an order, so I just want to do that on the record. All right. Next, before we address the defendant's motion to represent himself, Mr. Parvin, you wanted to say something.
Yes, it's come to my attention that rather than file all charges at once, where Mr. Myers would, I guess, be bailable as a matter of right, this whole situation seems to be piecemeal filing. There are Tucson Police Department officers, I don't know if they're in this room now or if they're waiting outside, ready to arrest Mr. Myers on new charges that will be consolidated with this court, which will therefore deprive Mr. Myers opportunity to respond and represent him pro se, therefore forcing me to be on this case against Mr. Myers' wishes to represent himself. I ask that we be, if the state seems to know what's coming, that since this court has jurisdiction for these new charges, I ask that we do an initial appearance today immediately and set release conditions so that Mr. Myers can continue to represent himself, because otherwise we're going to have a real problem after this court grants this motion, because now he needs new attorney on the new initial appearance. And then I'm back in this with the same kind of Feretta motion doing this again. We got a real problem, Your Honor.
Well, so we have a CR pending now. Defendant's been held over, and I'm going to rule on that. I don't know what's going to happen if they're going to file an amended indictment, if there's an arrest and they want to go forward on an amended indictment. That there's nothing pending that I could. I understand your issue, but there's nothing there's nothing pending that I could address.
Well, I wonder if the state has any information at all, because considering there's an arrest, that he's going to get arrested on new charges. I just talked to the officers, so that's kind of it's going to pose a real problem here. How is Mr. Myers going to respond to motions pro se? And at the same time, how am I going to be withdrawn? He needs representation. And then if there are new charges on new arraignment, the court's going to have to reappoint me again and do this all over again. So again, does the state have any information of all? Because, I mean, these officers seem to have information.
Ms. Stiles?
Your Honor, I notified defense counsel yesterday that there were likely new charges coming.
Okay.
And so this defendant just happens to be committing new offenses. And so he faces, just like anybody else who would be ongoing criminal activity would be facing new charges. That's the position he's in. And
let me ask this. If that occurs and it proceeds and there's an indictment on the new charges, would that be in this CR or a new CR?
It would be a new CR.
Okay. And that would be assigned to me, because typically we assign all matters to the same Superior Court judge. So, but those aren't pending. Would you agree with me that there's nothing I can take action on with respect to that? It's speculative.
There's nothing that he would have to go through the process, but there's nothing currently that would be in front of the court for the court to be able to do anything on.
But the new charges wouldn't affect these pending charges, correct?
Correct.
Okay.
It would, Your Honor, because it's going to affect potentially his bail eligibility, and that's a problem if there's no basis for the new charges. That's the whole point of Mr. Meyer's slap motion. Now, I would have filed it slightly differently. Maybe I would have done a motion to dismiss under the grant or motion to remand once the grand jury transfer comes in. There are things I would have done differently than Mr. Myers, and I would have taken more time to do it. That's the reason I have to withdraw, so Mr. Myers can do everything the way he wants, and he may or may not be, right or wrong, doing it different than me.
Right.
But that's a real problem because if I don't know where the officers are, they work here. I don't know if they're in here now and can give information. But if this court proceeding concludes, we go out there and Mr. Myers gets arrested, brought into custody. He needs a new initial appearance. I don't know when that's going to be. Obviously, the court's going to need back in on it. Are we going to have to reappoint me again and then go through a new withdrawal? And then I'm wondering, at this point, I'm just trying to think for.
Well, we could do a couple things. We could put off your motion if you'd like to withdraw. I mean, that would be the.
He needs his motions filed. Sorry.
Hold on. The court system goes in steps, and we're at one step right now. I don't know if he's going to be charged in a new case or not. I have no information on that. But if you in consulting with your client would prefer to stay on now, and then we could reset this, or we can go forward. That's your choice.
I think what's going to happen, as procedurally crazy as this will be, we'll proceed today with the motion to withdraw and Mr. Myers' request proceed pro se. My understanding is all of his motions have been filed, which will prompt the state needing to respond, and that way at least everything's filed. And I'm guessing I will be notified of the new initial appearance. Now, again, I have a calendar as well of my other OCAT cases, and I'll have to rearrange things to try to come to the new initial appearance. I'm guessing I'll be appointed again, and then on whatever new case is, we'll have to be right back here on the new case and do this again. I guess it needs to be done twice, is from what the court's understanding is. But we'll do this today. We'll get through it, and Mr. Myers, I will be with you. We'll talk to the officers and find out what's going on before you are arrested.
Yeah, I think that, again, we have to concern ourselves with what is currently pending, and I can't speculate as to the different steps in the criminal process, and I don't get the case back until the defendant is held over if there's a new case. So, I think
this is just a very unusual case.
They did this on purpose.
Hold on. I'm just explaining to the court why this. I understand everything the court's saying. I just hope the court understands how rare this type of situation is.
It's unusual, but people actually pick up new charges all the time. It's kind of a.
But I haven't done anything.
I understand, but I'm saying it's unusual where a person wants to represent themselves and respond to motions, but normally it's just say the same attorney can help them while they're in custody.
They're doing this so I can't type at my computer. They just want me away from my computer.
Okay, all right. That's not our issue today. Today our issue is whether you want to represent yourself. So, and I know the last thing I wanted to mention is that, Mr. Myers, I understand that when you're filing things through our e-filing system, that you're having a hard time marking action for a copy to go to chambers. And we checked on that, and there is only one filing system, and it is possible to mark action by the division. So
I don't know where that is on there.
I
even called the clerk and went over it on the screen with her.
Mr. Parvin, have you tried to go over that with him? Just show him how it works.
On the filing system, honestly, I've had some issues there as well, where even if it gets there, it goes to a pile. I find it much easier just to deliver directly to the clerk with the courtesy copy, because I know then there's a response that's been received. You don't always know it's been received if you use the action online, but I believe, I understand the court will understand if it doesn't get to them, there's a reason you tried. I don't think the court's going to hold that against you, Mr. Myers.
The only thing I could see on there is it says emergency judicial action.
You don't need that.
Right.
There's a way to do it. It's just always, I should say, more complicated.
I don't know if it's because I'm pro se and they won't let me just send things directly.
No, it's only one system.
Well, it won't matter now because they're going to arrest me and play games.
Mr. Parvin, what would you? I wouldn't. If you have problems with the system, how do you do it?
Well, it's not that I've had problems. I've never had problems filing anything.
Right.
I've had problems where it thinks it sent it to someone, but it doesn't. It maybe it's just on someone's desk or doesn't get printed out, or it's in a list of documents. So I find it best, although as the attorney, it's easier for me to just follow up with for example, the state or the chambers and say, did you get this? And sometimes I say, could you please email me a copy? And that way I have it. But I understand Mr. Meyer's situation. It's a little different. I think it'd be best to use the system where it gets to your court at some point, and if the court does not have it, I inform Mr. Myers it's still filed on time, and then the court would just explain, okay, it's not going to use that against Mr. Myers simply because it finally got to you at a later time.
So the issue that, I mean, it's important that we get copies. What I don't want is for Mr. Myers to email us all this stuff that's not just a document. If we don't get a copy, we don't know it's filed. We don't keep a running, we don't look at every case all the time.
Right.
We take action because something's served on us.
And that is the problem I've had before when I thought I didn't follow up and I thought it was served on our court and it wasn't. Again, it was easily fixable because we just got an extension of time limits. But I understand Mr. Meyer's concerns. That does happen sometimes where you never know for sure if the person receives it. You don't get confirmation unless it's by email.
All right, so I'm going to amend my order from yesterday that Mr. Myers can provide a courtesy copy. When you email me, Mr. Myers, you also have to copy the state prosecutors, okay?
I guess.
All right.
I feel like this hearing is a.
Hold on.
I mean,
we're just talking about procedures.
I know I'm going to get arrested when I walk out, and they're going to try to hide me from my computer, so I can't even.
You're going to get a new hearing on that.
How am I going to be able to even file anything in this case if I'm in jail?
I don't have any jurisdiction over that. We're talking about this case and what we're doing today.
You know what's going on. You saw the slap. It's going to be a slap in the next one.
The court's not going to read everything in 30 seconds.
Okay.
It takes time.
Mr. Myers, we're talking about procedures in this case, okay? I'm trying to help you so that you can so you can represent yourself.
But I'm
hold on. You don't talk over me.
I'm not apologizing. Go ahead.
I'm just trying to find a procedure so that you can file things properly so that I get notice. But I don't want to hear the arguments and the invective towards the other side.
I don't.
So I will amend my order that when you file something, you could email the state's attorneys, Ms. Stiles, all right? So you should never email something to a judge without the opposing party knowing about it.
Talking about like when you add the names? CC,
yes.
right? Okay.
CC, yes.
And I'll suggest, Mr. Myers, no commentary. What I do, you simply add the motion. You say, this is what the motion is in the body. That's it.
Right. Then we'll make sure we have it. But I don't want you've added a lot of stuff in the motions that.
Yeah, because this is all a BS case.
Okay, but it's not proper. I can only consider what's filed in the court file.
I understand what you're saying, 100%.
All right. So are we ready to proceed to the defendant's motion to represent himself?
Yes, Your Honor. Mr. Myers, you have filed everything, right? So even if you're brought in custody, you have nothing else to file at this point.
As to the motion to represent yourself.
You're talking about the motion to represent myself.
Right.
I filed the notice of appearance with you. That's what we're having
I'm saying
a
even
hearing
your
on.
slap motion's filed. Everything's
My slap
filed.
motion's filed, but I had other stuff, Rule 15 and all that, but they knew what they were doing. This is dirty tricks.
I think everything's filed, Your Honor, where we could proceed.
All right.
That way you're not harmed.
My thing is if you let...
Hold on, Mr. Myers, we're proceeding.
I know. He was saying that initially a few minutes ago that, there was an option of, waiting a little bit to see, because, they might pull more tricks out of their sleeve. So the thing is that in order to make sure that I have an attorney, but my thing is I'm loath to do that because I want the slap motion heard immediately. So if I don't go pro se right now, that would delay you being able to act on the slap. You know what I mean?
Correct.
But it's also knowing that you left the house today with your wife's car half fixed, and now I got to go to jail. You know what I mean? And my wife can't get to work as an attorney in town because this is the level they want to take it to. I don't know. You know what I'm saying? What's gonna?
Okay.
I have
now,
a suggestion. Hold on.
Now I have serious concerns about these people being ethical.
Hold on. Your Honor, I will accept the appointment on the new charges, consider the fact it'll be a separate case number that will address that. That way I'll be appointed on the new case if you're brought to custody.
Will it be brought
you
in?
Can still, eventually. And then we'll do this again on the second case.
So, yeah, there are no new charges pending.
Yes, there are. They're waiting in the hallway.
Hold on.
No.
You'll get an immediate court date on that.
There's a process. If you get arrested, then there'll be charges filed. They'll take it to the grand jury. If there's a true bill,
well, how would I?
It's the one where they got 10 days to get the grand jury. Okay.
So there's the new charges are not before me.
They're gonna arrest me when I walk out.
It's not before me.
But then I'm gonna go to jail and I won't be able to talk to you.
I was hoping it was already filed, like some sort of indictment. That wasn't the case. That's why I brought it up. Unfortunately, it's not yet filed, which means you have to go through the process, which I believe I told you about 10 days.
My car's sitting out there.
Okay. We're here on
Why
the
can't
waiver.
we be respectful and professional?
I'm trying to be.
No, not me and you. These
we're not talking about that.
We are though, because you know that as soon as I walk over here, and then I'm like, how am I going to be able to respond? If you say, if you need further briefing in the slap or something, and I can't do it, then I'm screwed.
No, it doesn't work that way. If you're in custody and can't respond, we'll give you additional time. But it won't work that way. I'm not going to. No, it doesn't work that way. You're not going to be prejudiced in this case because you've been arrested on new charges. Okay?
Yeah, they're going to say that I committed a felony while I'm felony for a bond.
That's different.
For making a meme.
That's different. That's different than your slap motion. All right.
Well, I'm going to put a new one on the next one.
Okay, you can do that if there's new charges filed. That's not what we're here for today. Let's
Well,
really.
I'm scared that if I give up my right now, I won't be able to have it in the next case.
Have your right to rep attorney?
Yeah.
No, it's a separate case. I accept it. I'll accept the appointment on the new
So you get a new attorney in the new case, and then you can waive your right to that attorney,
Okay.
and you can file a slap motion in that case.
So there'll be CR over here, CR over here,
Correct.
judge whatever, judge or you maybe you.
Same
Okay,
judge.
so it'll be 14 over here, whatever the new over here.
My understanding is the concern was I'm not ready to file a slap motion. I don't know if it's proper or not. It sounds like there is some merit, but I would have done it differently, and which means if I stay on this case, technically the court has to say it goes through me. That's why I'm withdrawing so that your motion will be filed.
That's what I'm trying to say.
Okay. All right. So, Mr. Myers, I can have you stand and be sworn by the clerk first. Then I'm going to ask you some questions about your waiver of right to counsel.
You solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Have a seat. Mr. Myers, I'm going to ask you a bunch of questions, okay? And it's just the rules I have to follow before I can make a decision to allow you to represent yourself. And they're very standard questions.
Okay.
And it's from Criminal Rule 6.1, okay? So, do you read and understand English?
Yes, sir.
What's the highest grade you finished in school?
12th.
Graduated high school?
Well, I have a
GD?
No, I have a college diploma and 2 technical degrees, a paralegal degree that I got in prison.
Okay. Are you under the influence of any drugs, alcohol, or medication?
Right now?
Yes.
No.
Have you ever been diagnosed with a serious mental illness?
No.
You have the right to counsel for all stages of the proceedings, including appeal. And if you cannot afford counsel, you have the right to a court-appointed lawyer at little or no cost to you. Do you understand that?
Yeah, so I can go back to a lawyer.
Correct.
Right.
If I allow you to waive your right to an attorney, do you understand that you can change your mind and request to have an attorney represent you going forward?
Thank you.
Is that yes?
Anytime moving forward later on, I can go for myself for a little while and then say, you know what, I want a lawyer.
Right.
Motion?
Yeah, you would file, or you could just say in court.
Okay.
All right. So do you understand you have that right?
Yes.
All right. Next, I want to talk to you about the risks of self-representation. First of all, I want to go over the charges. So you've been held over for trial on an indictment that was filed on March 7th, and there are 14 counts to that indictment. Counts 1 through 6 are each Class 5 felonies. If the state can prove that you've been convicted of a prior offense, it takes you out of first-time offender status and makes you a Category 1 offender, which means you're not eligible for probation. So if you're convicted, prison only. Each one, the mitigated range is a quarter of a year, that is 3 months, and the aggravated range is, on count 1 is a quarter of a year to 2 years. That's a Class 6, and then the others are all Class 5s, counts 2 through 6, where the sentencing range is a half year to 2.5 years. And then counts 7 through 13 are Class 1 misdemeanors, no prison available. There is probation available, or I could sentence you to 6 months on each. And as to all these, some of them may have to run at the same time, but some can run one after the other. So you're facing a substantial amount of prison. And then the last count, count 14, the stalking is a Class 3 felony. Again, if you're a Category 1 offender, the sentencing range is prison only 2 to 8.75 years. So you're easily looking at the possibility of a long time in the Department of Corrections. Do you understand that?
Can I say something back?
I want to know if you understand that.
Yeah, that's why I wanted to clarify something you said right at the beginning of that little section.
Uh-huh.
About the felonies prior.
Okay. And you're under oath, and anything you say can be used
I
against
was
you.
wondering if you meant, do they have to be in Arizona?
No.
Okay. Yes,
They
I
have to,
understand.
they have to be within a certain time period.
Yeah,
though.
they're
That-
26 years old.
Hold on, there is a way to strike it, but that's down the road.
Okay.
Okay.
So to answer the question corresponding to that little segment, yes, I understand.
Okay. Now, if you do represent yourself, you'll be held to the same standard as lawyers. Do you understand that?
Yes, sir.
And you, I believe you have a paralegal degree, you said? But you understand that your lawyer, Mr. Parvin, has attended and graduated from law school and has practiced as a lawyer for a long period of time. Do you understand that?
Yeah, my wife was a judicial law clerk for 8 years too, till they got her fired in this case.
Okay, so what I'm saying is, if you're represented by a lawyer, you'd be represented by someone who went to school for a long period of time and has practiced for a long period of time in this area and has a lot of knowledge and wisdom and experience that he can bring to bear in representing you that you're just simply not going to have by not being a lawyer. Do you understand that?
Yes, sir.
All right. If you represent yourself, you'll have to do certain things like pick a jury. Have you ever picked a jury before?
Yes, sir.
You have? Okay.
And I won the case.
All right. You have to make opening and closing statements, and you'll have to cross-examine the state's witnesses and examine your own witnesses. Do you understand that?
Yes.
And you may find it difficult to make arguments to the court. Again, if you watch your lawyer do it, he's very professional and smooth, and it may be harder for you to do that than it is for him to do that. Do you understand that?
I do. You can go to school for 10 years and still not have ethics, though.
Okay, but that's not the question before us today. The question is training and experience. And what I'm trying to tell you is that if you represent yourself, you're giving up a resource of someone who's very trained in this area. Now, currently you're out of custody, and I understand that maybe you'll be in custody. If you're in custody, as the case proceeds, it's much harder to prepare your case
Obviously.
than it would be for your lawyer to prepare your case. Do you understand that?
I do, and that's why I'm trying to figure out why couldn't they just do this all at once?
Okay. And things that are hard to do would be to subpoena witnesses, review disclosure, and interview witnesses. Do you understand that? Although we will make provisions to try to make that as clear as possible, it is just more difficult if you're in custody. Do you understand that?
Yeah, I understand the game.
It may be harder for you to file papers in court. Today, we've talked a little bit about the difficulty, and we're trying to mitigate that, but you understand it may be difficult to file papers in court as compared to your lawyer who does it all the time.
File with court, you mean if I'm in jail?
No, just generally, just being
You mean throughout the litigation?
yeah, just being a pro se person,
Yeah.
it may be harder for you to do it
Get
than
them in and stuff, right?
all right. And then when you represent yourself, you're going to have to stand up and argue to the jury, and in your presentation, you may have less credibility than the lawyer would have. Do you understand that?
Not in this case, but yes.
All right. Well, you think I'm just telling you that's a possibility.
I
I'm not.
understand the optics. Yes.
All right.
That's what you mean, right? The optics of it.
Yes, exactly. The services of an attorney can be of great value in determining whether the charges against you are sufficient as a matter of law, whether the procedures used in investigating the charges and obtaining evidence against you is lawful, including the lawfulness of any search, seizure, or police questioning. If an act you may have committed actually amounts to the crime for which it is charged, or if you have another valid defense to the charges, or if you're found guilty, whether you should be placed on probation, required to pay a fine, or sentenced to a term of incarceration, and whether appellate review could be justified. Do you understand that? That services of attorney can be of great value in determining those matters?
I do, and if it gets past the slap motion, you never know. I might have to get one.
Okay. And as we've gone over, if you're found guilty of the offenses charged, that you do face the possibility of being sentenced to a term of incarceration, even though you've given up your right to an attorney. Do you understand that?
Yes, sir.
Having gone over the risks of self-representation, is it your choice today that you still wish to waive your right to an attorney in this matter?
In this matter.
In this matter,
Right.
this CR matter.
Not whatever they're going to do out there.
Correct, this case, this
Yes.
pending before us. And the answer is that is yes?
Yes, sir.
Has anyone promised you anything if you waive your right to an attorney and decide to represent yourself?
No, sir.
Has anyone forced you or threatened you in any way to waive your right to an attorney and decide to represent yourself?
No, sir.
Have you had the opportunity to discuss your decision to waive your right to an attorney with the attorney that's currently representing you?
I have. We didn't know this was coming though.
Okay, but again, do you think you need to talk to your attorney more before you decide to waive your right
Not
to a
in
lawyer?
this case.
Okay.
I have one concern, Your Honor.
Sure.
Is the slap motion can be done at any time, and that's the only concern I had. I didn't really feel comfortable filing that. What has a time limit that I'm worried about is a remand to the grand jury. I don't know when the transcript's coming in. That is a motion I would strongly recommend looking into filing. I don't know if Mr. Myers is capable of filing that motion in custody or even knows when he'll get it, but that's a strict time limit that really can't be waived by the court, although you can get extensions. I know how to do that. Mr. Myers may or may not know how to do that. That's my only concern. But again, I'm not going to file that slap motion. That's Mr. Myers' motion. That's why I need to be withdrawn. I don't know if there's a way to appoint me as advisory counsel and give me permission just for that one basis to look into the grand jury and file that one motion only.
Well, if I grant his motion, I'm going to appoint you as advisory
As
counsel.
advisory, can I still file that motion on his
Well,
behalf?
hold on. No, because then you're his lawyer. Hold on. What's the deadline for filing a motion for remand is based on what date?
So it's 45 days after they receive the certified transcript, so.
Okay. And you haven't received that yet?
I'm not, but I'm worried Mr. Myers in custody would not know how to do that. I would. That's my main
Okay.
concern with this.
I could extend that to 60 days. Ms. Alves, do you have any objection to that?
No, and like I said, I don't know when the transcript's going to be ready, but they still.
Okay. All right.
We're not up against that timeline, so if they need more time even than that, we can always keep
Yeah.
adjusting it.
So for today,
But can he file it or does it have to be me?
It has to be you.
It has to be me.
But I will buy you time. I'm giving you time. Sorry.
yeah. Okay. So what we're going to do is today I'm going to enter an order, and I am ordering that the defendant has 60 days to file a motion to remand once the defendant receives a certified copy of the transcript of the grand jury. So that's 60 days. If we're bumping up next to that, then Mr. Myers, you'll have to ask for additional time. Okay? What?
If I'm in jail and they mail it to my house, I mean, how would I even know I got it?
Don't you?
Send me copies, even though advisory.
So the clerk's office sends out the copies, but we'll make sure that he gets it.
Okay.
He'll get access to all his
Yeah.
disclosure.
If you're advisory counsel, I believe you continue to
When I
receive.
get notice of court dates, I don't know what the rules of disclosure are for that.
Okay.
So we will make sure that Mr. Parvin also has a copy of everything, so he gets everything so that he can go and discuss it with his client. So even though Mr. Myers is representing himself, he has his advisory counsel, so we make sure that we're still sitting things through Mr. Parvin.
Okay.
But that's not really representing myself.
Well, do you not want me?
No, I'm saying-
right. You could get me off. If you want
I'm
me,
just
you
trying to
want-
make sure that like if they're gonna send stuff to him, is it what then he gets it to me?
Yes.
So-
He's your advisory counsel. He'll still be able to communicate with
But
you.
I'll also get sent a copy, right?
You should. Correct.
It's going to send to both, is my understanding.
Yeah, there may be, if depending on his custody status, there may be different things with the media, but like we work with that all the time with people who are in custody representing themselves.
Okay.
So he will have access to everything.
The next thing is,
You hear that, right?
Yeah.
You heard what they said?
Yes.
Yeah, they're dirty.
Mr. Myers, to waive your right to counsel under the rule, you also have to sign this notice of waiver. So Leah, can you hand that to him? And it's on page 2 that you sign it, and I sign it as well, and then it gets filed with the clerk.
Do you want?
All right. The defendant, Mr. Myers, has signed the notice of right to waiver of counsel in open court. We'll put that date on there. The date is the 20th. Court makes a finding that after discussing the matter with the defendant and have observed his demeanor, that he has knowingly, intelligently, and involuntarily waived his right to counsel. The court will appoint Mr. Parvin as advisory counsel, and then we will talk about the schedule here. So there's that. That gets filed in open court. And
And Your Honor, I don't mean to interrupt. I just got a text message. Someone mentioned they can't hear any audio on the broadcast. I just want to make sure this whole thing was recorded with audio.
Yeah, it says it's streaming active.
Okay, I'm not
So.
sure why I was sent that text message, but it's just what I was told.
Okay.
It says can't hear any audio on the broadcast.
All right. Let's look at the schedule. So we have a motion to modify conditions of release scheduled for the 27th. And as to that, Ms. Stiles, I'd like, if you're going to present evidence at that, which I assume are videos, is that right?
That's correct.
Could you provide those copies to me beforehand so I can watch them beforehand so we don't have to just sit and watch all of them? And then you're obviously going to disclose copies to the defendant as well, correct?
Yes, absolutely.
Okay.
Your Honor, how would I prepare for this in jail? You just told them to disclose all this. We went out, they could have told me this yesterday. They knew we were setting this hearing. They knew that I needed the evidence. We went over this yesterday. We made a big whole stink about making sure I had the disclosure so I could have due process ahead of the hearing. And now I'm just being I was just appointed and under the understanding that, after this hearing today, they would provide it to me and I would go home and start getting, preparing for next week. Why they couldn't just bring this up at the next conditions of release hearing, you know what I'm saying? So that I could actually make cognizant arguments, because now they're just going to give you, it's like, I'm not even, the evidentiary hearing is a trial, is a hearing on the merits of their motion. Like, I don't even get to make arguments because they're going to put me in jail and avoid me. That was the whole point. I wanted you to order them to disclose it to me. And you said, well, we got time for that. Miss Stiles, make sure you disclose it to him so he has time to get ready for the hearing next week, right? So they're saying, so all of a sudden you just asked her right here in open court, Miss Stiles, I assume you're going to be showing me this, that, or whatever. Could you send it to me, right? So that implies to the court right now that they knew as of right now what they're going to send, or yesterday or any of that, and they could have apprised me of this ahead of time, but they're waiting to right now to put me in jail, and then they're going to show you the evidence. I won't get to prepare for the hearing. I'll come there looking like a dumbass in a clown suit. And then they'll be like, oh yeah. And I had no time to prepare, no time to argue. And my lawyer can't prepare because I just took him off the case. This was all a setup. They could have.
Okay. So, Mr. Myers, a couple things. First of all, if you're in custody next week, then there wouldn't be a need for a motion to modify conditions.
What are we doing?
And so we would put it off. Or if you're not able to prepare for it and we're there, you can tell me that you've been unable to prepare for it. What the state said yesterday, though, was all the videos that they're going to use come from you, so you've actually seen the videos.
But that doesn't. Sure, that's not process. So I'm supposed to assume which ones they're going to use. I don't know I make hundreds of videos. So that's like saying we're going to use something the color blue.
Okay.
That's not properly telling me. Now, if they're talking about for the whole case, like in the 14 counts, that's what I assume they meant. But if they're talking about specifically to prepare for the evidentiary hearing, and they're going to bring up videos there, they need to tell me, because those are different. Because remember now, this is a hearing for the conditions of release, which means things that happened after the indictment, right? So now I can see for the things in the indictment, absolutely I should know because I have the indictment and I could read it in the police reports and all that, right? But I'm not. But the conditions of release hearing are things that have happened since then. I haven't been indicted, or I haven't been. You get what I'm saying? Given disclosure specific to, because when they filed their motion to modify, they didn't include no exhibits, no nothing. There was just, hey, we just want you to take our word for it. Trust me, he did this. And so, and it was not even him, it was somebody else. And so what I'm saying is that how do I, not for the indictment, which is, like you said, you got time for that. Specific to this hearing, now they're going to put me in jail. And they could have, it seems like they know what they're going to present yesterday. Like she said in open court, it's going to be videos of me. Then she should have had no problem saying, it's going to be the video that you made called this. It's going to be the video you made called this. It's going to be the video you made called this, or posted on this or that. No. Videos. I got 586 videos.
Okay.
Which one?
So, Mr. Myers, at the hearing next week, if you have not been able to prepare for that hearing, we can put that hearing off. I don't have to decide it next week. So, do you understand?
May I respond?
Sure.
Your Honor, so we've already been sending out the paper disclosure that has the information about all the videos that we have. We also are preparing, I believe it's going out today if it hasn't already gone out to Mr. Parvin, but we're sending him out, and now Mr. Myers will make sure he has access of all the videos that we're referencing. I am also happy to provide a list that I can send to Mr. Myers that specifically identifies each video that we're going to be doing. So even though he produced them, we're absolutely disclosing them, which is require that we disclose those to them, and we are absolutely doing that. We just couldn't give them all, immediately because we have legal obligations to do redactions.
So, Mr. Myers, when we come back next Thursday, if you think you haven't had a chance to prepare, we can always bump the hearing.
Yeah, because I've asked her 5 times for that, and she said she has it now. What, paper? She's mailing it to my house while I'm in jail? This is a game.
Okay.
I don't suppose the court has Friday available, so I can come too. I'm just trying to pick a date when I would have more time. As advisory counsel, Thursday is a really heavy schedule for me. If the court can do Friday on the 28th, I have an open schedule that day.
Well, the reason we said it yesterday is then we also had the victim's input, and Mr. Parvin was here. I don't understand what happened to the date since yesterday.
And I was withdrawn. If Mr. Myers needs me, I think the question is
Advisory counsel, right?
Except advisory counsel, he should have been preparing to be there because advisory counsel should be at all the hearings.
We were, but we didn't know that. Now I'm going to go to jail today.
Okay, hold on. So you'd rather do the 28th than the 27th?
That way I don't know how long. It sounds like it's going to go longer than I expected. And the Friday, I have an open calendar where I can be here as long as it takes.
We still have 5 days notice for the victims.
I can text
Okay.
right now.
Is she going to contact the victims right now?
Yeah,
Okay.
she's going to reach out.
Yeah.
All right, let's wait for just a second on
I'd
that.
appreciate it. That way, if it does go 2 or 3 hours, I'm still available.
Okay.
I thought
Okay.
it'd be only a quick half an hour here.
Sounds like they'll make it work.
Okay, so we're gonna change the hearing on the state's motion to modify conditions of release from the 27th to the 28th, and that will be from 2 to 4:30. I'll have set aside for that. Okay, so, and again, Mr. Myers, if we get there and you can explain to me why you're not ready to go, then we'll address that, and obviously Ms. Stiles can respond to that as well. And your slap motion is pending before me right now.
So me getting arrested or anything won't. This case can work independently from them arresting me when I walk out.
Correct.
Because you need to see that, please. While I'm here, can I stand up for a second?
Sure.
The slap motion isn't really something the criminal side of it isn't something that's really well defined yet. So it's not really even in the rules of procedure. So I don't even know, is it going to be a standard 10-day? Because it's not even something they're required to respond to unless you order them to.
Correct.
So I don't know, is there a set period that you have to make your ruling?
60 days.
Before you order them whether to respond or not.
Oh, so I'll review it and I'll probably try to get it done this week. I mean, it just depends. And if I order them to respond, I'll do that fairly quickly.
Okay.
If I rule on it without making them respond, I'll also get that out fairly quickly. So.
And also, my understanding is you can rule on it without an evidentiary hearing, or you can if you.
Correct. I could rule on it.
I would prefer to have one if, you know what I mean?
All right.
Unless you feel, you know what I mean?
Well, I have to make that decision. I've started to look through it. It's pretty long, like 25 pages or something. So I haven't read the whole thing yet.
I know.
Well, it's not your fault. I'm just saying, I started to look at it, but I haven't read, because you have a long paragraph as to each count.
Right. That's the only way I could do it. That's why I had to exceed, because it's like 15 pages for each count.
I'm not criticizing you.
79 to 80 page motion.
I'm not criticizing you. I'm just saying that it's going to take me a while to read it all and have to decide whether to order the state to respond or not. And I know, as you said, that it's new to include criminal actions in this anti-SLAPP, but it's there, and we'll address it. Okay, and that's what happens. Maybe you'll be making some new law here.
That's what all this is about, because I'm the only one being charged for these videos. There's 500 videos of the same person that nobody else is being charged with except me. There's video. So what I'm gonna go here. I want you to hear this right on the record. I'm gonna go to jail right now, and there's gonna be more videos made in the next 24 hours about the victim than there has been made in her entire life. So I'll be sitting in jail, and there'll be 500 new videos about the victim. She's going to get 500 new emails,
Myers,
500 new memes made about her. How does that protect the victim? It doesn't. This is a charade.
Well, it may be.
You better charge every single person. And I want you to address this on the record, because you said this yesterday, and we kind of talked about it for a second.
Can you slow down, please? Slow down.
Slow down. I thought you said sit down. I apologize.
Slow down.
All right. So I would like to address this, something you said yesterday, because it's very pertinent as the matter. You're the trial judge, right? And so, I don't know when I'll be able to get back to my computer to notice adjudicative fact, but you ordered me, not asked me, you ordered me yesterday to remove your email from public posting, right? Because Gina's email is not, you know what I mean? And so, but in the period of time that it was up, right, you did receive emails, right? We went over that, and I mean, are those people going to be charged with crimes? You get what I'm saying? And so So this is pertinent, and I want this on the record because the judge in this case received emails as a state of Arizona employee at his .state.gov, and nobody's going to be charged for those emails with a crime by the same agency that's charging me for a crime for other people sending emails to some, not even emails I sent. So in this case, sir, will you be charging me with 14 felonies for those emails you received yesterday at Gina's email? Because that's what we're dealing with in this case. I didn't send the victim any emails. Other people did. I'm going to jail right now for something other people did. So in that case, when we come back on Friday, you should have there should be a felony for each email you received, right?
So let me tell you how it works. Do you understand the separation of powers?
I do.
Okay. And do you understand who makes prosecutorial decisions? You understand that? Who makes prosecutorial decisions?
We're
Not
good.
me.
I know. But I'm saying, so I should expect to walk out there and get charged for all those emails you got.
I don't have any idea what they're.
Well, I mean, you would have reported them to the police.
I'm not going to tell you what I've done or not done. I don't charge people.
That's what I'm saying.
I hear cases.
You're appointed by the governor, right?
I'm a judicial branch employee,
That's what I'm
not
saying.
an executive
You're
branch.
not. What I mean is, over at like Justice Court, they get elected through votes.
Hold on. We have 3 branches of government. I'm in the judicial branch.
Right.
I report to the Supreme Court.
I understand.
The prosecutor is publicly elected. She's an executive branch official. Okay?
Right.
She does their thing. I do my thing. Different silos.
Right.
Okay?
And what I'm saying is you as a judicial officer of the state of Arizona, also people could make a video about you on there and say, oh, I don't think he wears nice shirts, or I don't like the ruling he made in that case, right? They're not going to get charged with a felony.
Okay.
But I am.
Right. Again, we're pending. We're addressing the charges that are pending before me in this case.
That's what I'm talking about. Because I'm being charged for things other people did.
All right.
That might be defenses, but we're just trying.
Yeah, we're not
I just
there
want to
yet.
make sure because I want to tell my friends to get
The schedule, and I'll just affirm the case management conference of April 15th and the pretrial conference of May 16th, both at 9 a.m. You are ordered to be present at those hearings. If you're not present, then the court can issue a bench warrant for your arrest. Do you understand that, Mr. Myers?
you, sir.
All right. Anything else we need to address today?
No, Your Honor.
Just that the court already said that in the event that jury trial does go, I don't think it will, that we would waive my presence that on the April 15th.
Oh, you mean the pretrial, the
Not the
case management conference?
Right.
And if they need to reset the hearing, we'll be fine with that. We can always work with the dates as we get closer.
Okay.
I don't want
Yeah.
to reset it now because I don't think that trial's going to go. That's
Okay.
what I'm keep
Yeah.
saying.
Why did you say that though?
What?
Why do you say it won't go?
Because things always, a lot of times you get notification, may either get continued or settled before the actual jury trial date.
Yeah, I'm not giving up my.
I'm not talking about you. I
Different
guess.
case. He's got a different case. Maybe he's got a conflict on that date, but he's saying that
Talking
case.
about in this case, the trial
No,
might not go.
no. I was talking about a reason why it could probably still be available on the 15th. I'm not going to make continuance unless I know for sure.
In your case.
Right.
Okay, I thought you meant in this case.
Yeah. All
'Cause
right.
I don't want to continue anything.
I know you don't. That's why.
This shit should have never happened.
With that, we're adjourned and you're excused.
Okay, so I was talking basically the whole time since after the hearing. I didn't realize it was muted. I apologize for that, everyone. Okay, so I guess I get a take 2 on that. Okay, so I'm waiting to get confirmation from Reluctant Prophet that he is in fact getting arrested, or a phone call from Lane that he is free. But I'm going to bet on the arrested side. The way that Lane explained it to me, because obviously he saw this coming. It's not as if he's getting, they're getting one over on him and surprising him with these things, but the way he explained it was he'll be arraigned on the new charges, and because he's out on felony bond, and depending on if the charge he's catching right now is another felony, if those are the current conditions, if he is on felony bond and picks up another felony, they can hold him without bond. But because it is 2 felonies, and because they're talking about withholding bond, I'm pretty sure that there is a probable cause hearing for the new charge. So that would be obviously a good thing, because I think the new charge is the felony t-shirt charge. So he's yeah, so hopefully there would be a probable cause hearing, and obviously there wouldn't be any probable cause, so it would go back, it would revert to the prior conditions of release. Now, you got to check me on that. I'm not, check my facts. I can't believe they kicked Prophet out of the courtroom. Bunch of babies. Bunch of big babies. You guys remember where we left off in yesterday's hearing?
The College of Law is a building that has a public law library. Mr. Myers did not have any business to come see me specifically. He claims he's a news reporter. That was news to me. He told my colleagues I had his wife fired. My colleagues
stand by, I'll be right. I'll be right back.
Put in a terrible position of not knowing what to say to someone that they knew had been, as far as I'm concerned, harassing me and threatening me. With no one around at 5 o'clock on a Wednesday. So it caused a lot of fear and upset for me personally.
And the language that's in there, are you saying that it's because of those cases and the idea that a court can regulate conduct, and sometimes conduct and speech can be mixed together? Are Are you saying that that language is appropriate, or are you suggesting it can be narrowed at all?
I believe that it's appropriate because it refers to me specifically and the harassment, threats, and stalking that I've received, not just from Mr. Myers, but a very large extent from his followers. If I were to put every single thing that had occurred, we'd have about 100 exhibits in terms of names, things that have been said about me.
Why can't an individual post, and I'll just use myself as an example, I mean, someone could post whatever they want about me, nice things, bad things, and you know, it's not directed at me, it's just out there in the public. They're allowed to do that. I know I'm kind of more of a public figure than an individual, but I think it would apply to an individual as well. You know, people might send it to me and I might not like it, but that doesn't necessarily mean it's directed at me.
I do believe that it's directed at me specifically because of the contact that I've received specifically at my work email, my work phone number. I'm not really sure what someone might do.
I think that's different. If what I'm hearing you saying is that you're asking me to draw an inference that, maybe not an inference, but you're saying there's specific evidence that Mr. Myers is asking others to contact you essentially on his behalf.
I do believe that there is, Your Honor.
And the harassment statute, which is ARS 132921, says that a person commits harassment if the person knowingly and repeatedly commits an act or acts that harass another person, or the person knowingly commits any one of the following acts in a manner that harasses. And the first one is contacts or causes a communication with another.
Yes.
And it strikes me that you're telling me that these YouTube videos, what's in them, the fact that your contact information is in them, the fact that they are either explicitly or implicitly encouraging people to contact you, that is Mr. Myers is causing a communication through electronic means.
Correct. That is correct, Your Honor.
Just want to make sure I was hearing you correctly.
Thank you.
Anything else?
I do have, I don't know if we're at this point, a statement, if you would like me, a closing statement.
Well, I'll hear from Mr. Myers, and then you get the last word.
Thank you.
Mr. Myers, your thoughts on all this?
Can I go rebut what some of the stuff she said?
It's your time to make an argument.
Perfect. So, as you said, sir, you brought up the original harassment, however, but because this was a voicemail, that falls under 132916 electronic harassment. And also in the injunction for harassment statute 12-1809 subsection E, it literally says the court shall review the petition on file and any evidence offered by the plaintiff, including evidence harassment by.
Could you just slow down a little bit? I'm trying to listen to you, but you're going off.
My bad.
Fast.
I would get worried that you're going to cut me off. I'm sorry. The court. This is. I'm reading a section of the injunction for harassment in and of itself statute, 12-1809. You know, it lists them, and then what is considered an act for harassment for the purpose of this section. For the purposes of an injunction for harassment, the law is written a little different. The harassment you stated is not the legal definition for an injunction for harassment. 12-1809 E says if any evidence of electronic harassment needs to be reviewed, and then that falls under the electronic statute 132916, use of an electronic communication to terrify, intimidate, threaten, or harass, unlawful use of electronic device, and that covers social media. That law is newer because social media is a newer thing than the harassment law. The Arizona State Legislature recently made 132916, and it says it covers use of electronic, because we can all admit the first and initial 912 was a voicemail on an electronic machine, from my electronic machine to her electronic machine, and that's very clear in here that under 132916 C, this section does not apply to constitutionally protected speech or activity or to any other activity authorized by law. And when I'm saying that this is First Amendment protected activity, because like you said, she made no statements about me giving her the videos or sending them and saying, look at this, or any of that, or okay. I said, here's her contact info if you want to redress your grievances with this public official. I didn't say call her and tell her about my case with her husband. I said, if you don't feel, there's more to, I do think she had something to do with my wife getting fired as a law clerk across the street, but that's a different thing. And so that's more defamation, but we're not. So electronic does not apply to constitutionally protected speech. Also, this alleged electronic harassment took place at her workplace, the University of Arizona. That would fall under workplace harassment. And workplace harassment, 12-1810, injunction against workplace harassment, section M. This section does not, M2, permit a court to issue an injunction that prohibits speech or other activities that are constitutionally protected or otherwise protected by law, including actions involving labor disputes, all that. That doesn't really apply to me. But okay, and so, I wasn't residential picketing, that's just I'm just saying what applies to me, the protected speech, constitutionally protected activity. And then, this case has been settled in the area, I know she had hers, but Lafaro versus Cahill made this very, very, very clear. First, there's only one direct contact, that's the voicemail, sir. The voicemail, I called, I left
Call
that.
me the
We're not here to argue
conspiratorial
that. That was me, I left it on 9/12. Left that voicemail. That's the one instance of direct contact electronically through the medium of electricity to her voicemail. The rest of them, I made videos on my YouTube channel. That's my first, and I do own Freedom Productions, which is a news and media company in Arizona. So the fact she didn't know I was a news reporter, that's not necessarily my fault. She should have maybe done her research. I own a news company in the state of Arizona. I'm a news reporter. It's registered with the Secretary of State. So, this is what I do for a living. I do news reports. And so, also, in Lafaro versus Cahill, now I'm going to jump, because it said for under E, back to the original statute for the burden of proof to get an injunction in the first place. E was, we need to look at the electronic evidence in the light of the electronic harassment statute, because the harassment one applies to direct face-to-face or nearby type thing. And then, so for the purposes of the section of the injunction, that's under T, 12-1809T. For the purposes of an injunction for harassment means a series of acts over any period of time that is directed at a specific person and that would cause the reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct, in fact, seriously alarms, annoys, or harasses.
You're talking fast again.
My bad. It means that it's a series of acts, that would be, I'm just going to read it word for word.
You don't need to do that. I have the statute right here.
Perfect. So I'm focusing on the legitimate purpose part, and you opened with that, so we're on the same page there.
So tell me what the legitimate purpose was for listening to that voicemail that was Exhibit 1.
For listening to it or sending it?
Sending it, I'm sorry.
To ask her if there was any programs, because as it states, I feel like she wasn't completely truthful about her job. It says it right here on the website when you put her name in, that she's the Director of Special Projects at the James E. Rowlett College of Law. As a member of the Dean's Office, Shannon manages important strategic matters, projects, and relationships, working with a variety of stakeholders that are both internal and external to the College of Law.
So what special project were you calling?
I was calling to see if they, similar to what you asked, I wanted to know if there was any relationship between the U of A Law School and the city's prosecutor's office, where there was any, inside ex parte, whatever you want to call it, type stuff going on there, because Stacey Jane has the access to justice, and I wanted to go use it.
To my ear, when I heard that voicemail, your tone of voice did not seem professional, your language did not seem professional, you used vulgarity.
I didn't use vulgarity.
Well, maybe that's it.
That was the voicemail somebody else left.
Maybe that's in the eye of the listener.
That was a different voicemail.
Help me understand why that's...
Because I can. It's my First Amendment activity, and I only did it once. And it's my right to, as a news reporter, to call her and address her in my way. I didn't tell her I was going to threaten her, hurt her, any way, shape, or form.
What's the legitimate purpose for going to her office?
To interview her, to see if she got my wife fired. Because so the reason 9/12 was the voicemail, right? Within 2 hours of 9/12, my wife was getting an award she was a law clerk for a federal judge across the street. At 2 p.m., she was getting an award on 9/12. At 3 p.m., she was getting sent home because somebody called over there, and I believe it was Miss Walker.
And the legitimate purpose for including Miss Walker's contact information in the YouTube videos and asking your followers to reach out to her?
Constitutionally protected activity, and I'm going to make that argument right now. So under LaFaro versus Cahill, injunction harassment which prohibited alleged harasser from any in-person contact with alleged harassment victim was unconstitutionally overbroad because of its infringement of alleged harasser's constitutional rights to free speech. Alleged harasser was restrained from engaging in political speech in alleged harassment victim's presence. So what it's saying is I can go there. In this, very clearly it says that I can go there, and just because she felt harassed, it literally defines what legitimate purpose is in this case. And so it's defined the fact that you have to have more than, the in-person contact part, that is not, because I have the right to go there and ask her for an interview. And another point I want to make is that she claimed that she contacted her colleagues, the University of Police Department, all that, on 9/23 or on 12 after I left that voicemail. She claims that. But then I went there on October 9th to the law library building. Are you familiar with the building? There's the law library in the bottom, and then there's offices upstairs at the U of A Law School.
Vaguely, it's been a while.
All right. Well, that's the building we're talking about. We're talking about there's the law library, and then there's offices upstairs. So she's saying that when I first left that voicemail, she called the U of A police and they told her to take her name tag down, right? And all her colleagues were worried. But then when I went there on October 9th, instead of them seeing me, and they all knew I was trying to harass her, instead of them saying, oh, sir, she's not here, let's call the police, oh, we were told to call something, they said, literally, sir, hold my hand, we'll walk you right to her office. These colleagues that were supposed to be so frightened of what's going to happen to Shannon, in the video, you'll watch them say, she's right over here, and I say, no, I don't want to go to her office. They say, oh, it's fine, it's open to the public. You can walk right over there, I'll go with you. So these colleagues that were put on notice, this crazy man was stalking and harassing her. When this crazy man showed up at her work, they literally, first, I met somebody in the basement, not the basement, the first floor, long before I went to her. I said, hey, do you know where Shannon Walker's office is? She could have said, hold on, let me give you a second, and go and call, hey, there's this guy here, he's the guy, he's looking for you, what's going on? Is there something we should be worried about? None of that.
Mr. Myers, I understand the argument you're trying to make there. Go on to your next point.
Okay, thank you. So the statute authorizing injunction against harassment is not unconstitutional in all its potential, but it cannot be construed to exclude political speech from the definition of harassment, okay? So in context of injunction against harassment, a single incident is insufficient to support a finding of harassment, which requires a minimum of 2 incidents. That's in Wood v. Abril, Appeals Court 2018, right? State statutes concerning orders of protection do not authorize their use to discourage people from yelling or engaging in harassment of the type prescribed by statutory provision that governs injunction against harassment, nor do they authorize the use of firearms restrictions to provide incentives for positive behavior or to teach people a lesson about civilized conduct. And you said it, I sounded...
Talking awfully fast again.
I'm sorry. You referred my language being uncivilized. That's legal. That's what Mayhar versus Acuna.
All right, guys, I gotta fear the worst here. Let me see here. That phone number, that email, guys. Everybody needs to know that they're being watched. No news online. I assume at this point he's been arrested, so no word from Prophet either. So if anybody else has a sassy, if you can get through to somebody and confirm with me, I'd appreciate it.
Appeals Court Division 2 2012 says that you can't use an injunction harass to teach me how to act civil. Conversation between alleged harasser and third party did not, hey, you guys calm down back there, did not meet statutory definition of harassment under statute authorizing injunction against harassment. So the third party being my YouTube. Hey. State statutes concerning orders of protection do not authorize, conversation between alleged harasser and third party did not meet statutory definition of harassment under statute authorizing injunction against harassment, even though alleged harassment victim may have overheard a segment of a conversation. Alleged harassing act was not directed at alleged victim. That's LaFaro.
It's really hard for me to pay attention when you're going so fast.
My bad.
My brain turns off.
I feel you. I'm trying to. Conversation between alleged harasser and third party did not meet statutory definition of harassment under statute authorizing injunction against harassment. Even though alleged harassment victim may have overheard a segment of conversation, alleged harassing act was not directed at alleged victim. That's again LaFaro versus Cahill. Because essentially my YouTube channel is the third party, sir. So when I'm speaking to many third parties, we never refer to it as a 10 party. Whether she's one party, I'm the other party, a third party.
Why shouldn't I either find explicitly or by inference that by giving Ms. Walker's contact information, complaining about her and encouraging people to contact her, that's not you causing a communication with her?
Oh, absolutely. We have the right to communicate with her. I want as many people as possible to contact her, and they're going to keep contacting her under the First Amendment. Why didn't she get an injunction against that guy?
And why do you think that it's appropriate?
Because the Supreme Court has ruled on this. I'm going to read it to you.
Finish, please. Why do you think it's appropriate for you, in this case, to encourage others to call Ms. Walker to complain about things?
The people that pay her paycheck have the right to call her anytime they want, as long as they don't threaten her under true threats, which is what I'm going to read right now.
And you think you're allowed to cause other people to contact her on your behalf?
Absolutely. That's what the news does. They put out a news report and people call. And you know, just what you just said, I can go home right now and make a video saying, hey, call Griffin and tell him he doesn't know what he's doing. You can't get me in trouble for it. I've done it with Judge Walton when she issued this. So where's the ticket? Where's the charge? You can't stop me. Those same people that called her called Judge Walton as soon as this was issued. I don't see nobody getting charges. I don't see nobody getting injunctions. And what they said to Judge Walton was way worse than what they said in that video.
All right, we got about 2 more minutes, and then I'll hear from Ms. Walker.
Sound judicial policy ordinarily motivates us to avoid addressing constitutional issues unless absolutely necessary to resolve a case. LaFaro has failed to establish the statutory requirements for relief under ARS 12-1809, the injunction for harassment. However, we feel, and that deficiency is sufficient to vacate the injunction. Okay. However, we feel compelled to address the unconstitutional application of 12-1809 to permit an injunction, placing significant restrictions on Cahill's freedom of speech. The injunction against Cahill was unconstitutionally broad because of its infringement on his First and 14th Amendment right to free speech. I also want to say that the injunction took away my right to the public law library, which is my 14th Amendment. It's a designated public forum, First Amendment protected liberty interest. To take away the law library, I need pre and post deprivation due process under procedural due process. So there's that whole angle too. They took away my right to go to a public building because she felt some way. That's also unconstitutional. The injunction against Cahill, 14th Amendment, that's what I was saying, as well as Cahill's right to free speech under the Arizona Constitution. We conclude that 12...
Myers, you're reading from the Cahill case. I've read it a number of times.
All right.
So I'm well familiar. All right. Do you have anything else you want to stress?
Well, I want to get this on the record for my appeal.
You don't have to. You've referenced the case, so everyone can pull up that case. It'll be there. It's in the record. Any sort of case that you refer to has been reported. The appellate court can pull it up themselves and read it. So,
wow. So what, you want some more, you want a different one you're saying than that?
No, I'm giving you about a minute to finish your argument before I hear from this.
Okay. Then we got Congressman versus Colorado. The Supreme Court held the First Amendment permits restrictions upon the content of speech in a few limited areas. Among these historic and traditional categories, unprotected expression is true threats. True threats are serious expressions conveying that a speaker means to commit an act of unlawful violence. The existence of a threat depends not on the mental state of the author, like you said, but on what the statement conveys to the person on the receiving end. So my mens rea doesn't come into that. Yet the First Amendment may still demand a subjective mental state shielding some true threats from liability. That's because bans on speech have the potential to chill or deter speech outside their boundaries. And important to prevent that outcome is to condition liability on the state showing of a culpable mental state. That kind of strategic protection.
Mr. Myers,
what?
Again, you're just reading from a case.
That's what you do. You cite case laws.
You don't just read from the case.
You do. I'm citing a paragraph in the case.
We have limited time.
You don't get. I have as much time as I need to make my arguments.
We have limited time.
That's your fault. Then continue it till tomorrow, and we'll keep going.
I will not.
You don't get to just tell me I only get 5 minutes to talk.
I actually do. I get to manage my courtroom how I think is proper.
So you
don't have to agree with it. You got 30 seconds more to tell me what that is. I've read that case. I'm aware of that case.
So why are we still standing here?
Well, because I need to hear both sides and then make up my mind. Anything else you want to say?
Yeah, that I don't care about contacting her at her house, but you can't take away the law library, and you can't take away my YouTube, and you can't take away my First Amendment right. I called her for what I made it clear. I want to know if she had anything to do with my wife, and if not, okay.
All right.
I don't need to contact her for that.
Thank you.
But I can go to the law school.
Thank you. Ms. Walker, you get the last word. I'm still struggling with that last sentence.
Well, you'll struggle with it all the way to this special action.
Mr. Myers, you've interrupted me again. It's rude. It's not nice. It's unprofessional.
I know.
Please stop that. Ms. Walker, Mike, can you address my concern? Again, I just think the language is broad. I understand why you want it. I'm just not sure it's constitutionally allowed.
I believe because it applies to me specifically, Your Honor, because it has caused me more emotional distress than I can really mention here. I feel harassed, I feel threatened, I feel frightened. I couldn't put my children in this injunction against harassment because I knew exactly what Mr. Myers would do. I don't know what his followers would do. I don't know if they would try to look them up or call their school. This is fear I've had every single day. And Mr. Myers and his YouTube channel and his followers who are here in the courtroom, I don't know any of these people who are recording me right now because I work at a law school and I'm married to a prosecutor. I find that very hard to understand, that I'm getting phone calls saying I should be raped and thrown in prison.
I don't agree with
Mr.
that.
Myers told them to call me over something that is not true. And even if it was, Mr. Myers' wife, who I have never met, I don't know if she even exists, has other legal remedies that she can follow other than her husband getting on YouTube, making false claims about me, questioning my ethics and my morals, my professionalism, and making my life what it has been for the past 3 months.
All right, thank you. I'm gonna take a short recess and think about this, and I'll come back and I'll give you my decision. Once I leave, all the recording devices need to be turned off, please.
All rise. Thank you. You may be seated.
Sure.
Sir, when I say all rise, that means everybody, okay? Thank you.
Am I allowed to say anything?
Not right now,
All right.
not on the record.
Thank you. That's kind of what I meant. Can I say something to her, like, politely?
Not right now, sir.
All right, cool.
All right, we are back on the record. Thank you everyone for your patience. All this paperwork is now online, and I'm not the best typist, so that's why it took me a little while. What I'm going to do now is tell you what I'm going to do generally. I'm going to explain why I'm doing it. When I'm done, I'll see if anybody has any questions or wants to make more of a record. I'll start with the plaintiff and then we'll go to the defendant. Here's what I'm going to be doing. I'm going to be affirming the injunction. I am going to be modifying it, however, and I'll talk about the modification and why I'm modifying it in a minute. In terms of my findings, I am finding that the plaintiff is credible and she is believable, that she definitely feels like she's being harassed. I found everything that she told me, not only about her feelings and what she's going through, but also just the facts, her summary of the videos. I'm finding that she's all credible there. I don't feel the need to look at the videos. I think both the parties have told me about them. As for the defendant, I am not finding him credible. I do not believe much of what he said. In particular, when he laughed, in my opinion, and I'm finding that he laughed and was excited about the voicemail from the third party and the awful things that were said about the plaintiff.
Objection, Your Honor.
You can't object to what I'm saying.
I can do whatever I want.
Actually, no, but it is rude. I'm just explaining myself.
You're being rude too, gaslighting me by telling me what I meant when I told you my girlfriend texted me.
I'm giving you a chance later to talk about it. I'm making a finding of fact. That
It's not a finding of fact, it's a finding of opinion. It's literally called an opinion.
Well, we'll disagree on that. So those are my credibility determinations. I am finding that there are a series of acts. I think the first voicemail from the defendant qualifies. The YouTube videos qualify. I believe the defendant was encouraging third parties, directly or indirectly, to make calls. And I think going to the court was another act. Finding that I referenced the statute earlier, ARS 13-2921.
Doesn't apply.
Please stop interrupting me. I will give you a chance.
Quit gaslighting the people, sir.
I will give you a chance to make the record. The statute talks about contacting or causing a communication. I believe and I'm finding that the defendant has caused third parties to communicate with the plaintiff through those YouTube channels.
That's going to get overturned on appeal.
Explicitly and encouraging them to contact her. Cases that support that are C versus SEVA, S-E-V-E-A, 2012 Westlaw 209751, paragraph 25. That case talks about a defendant who made calls to building employees and others with the
Calls, not call.
with the intent to
Calls, not call.
Sir, if you interrupt me again, I'm going to ask you to leave.
I'm about to leave voluntarily.
You're not going to get a chance to make your record.
You're getting overturned on appeal with whether I do or not.
So you've been warned. If you
You've been warned you're getting sued too.
All right. I'm asking you to leave.
Thank you.
Thank you.
So that'll be posted on, somebody will mail it to me or something?
We're going to give it to you right now.
Cool,
Just
thank
sign
you.
right here for me saying that you got it. Sign this right here saying that you got
Right
it.
here? Cool. You guys can talk amongst
Do you
yourselves.
want do you want your disc, your little flash drive back?
Yeah. I thought it was on the record for appeal.
Hold on, let me check. Maybe I misunderstood.
Oh, signature and here's your exhibit.
Sign here. and-
Why is my exhibit not being turned in for the appeal? That's what we turned exhibits in, for the record for appeal.
You've lost your chance to be here. You keep interrupting me.
That doesn't mean I lost my chance to put an exhibit on the record.
If you want to go outside
Just
and
sign
come
this
back
right here.
in 5 minutes after you calm down and follow the rules, I'll let you. Right now, you're not following the rules. You need to leave.
It's your choice.
Should you want me to leave my stuff here?
You want to come back in 5 minutes?
That needs to be, yeah, sure.
All right. Go outside.
Turn
calm
off
down.
your.
I don't need to turn off my recording.
Yeah, it has to be on your person.
Then I'm not, then I'm just leaving. What am I signing?
Sign right here.
If this isn't on the record, you're getting sued, you know that. So I'm gonna leave it right there. You don't get to tell me I don't get to put an exhibit in because I hurt your feelings, Your Honor.
Just put behind your back.
See you in court, Your Honor. I'll be filing the appeal when I walk downstairs. Notice of appeal will be filed when I get downstairs and the special action against you. So is that getting in, or do I need to put a special action on that too?
Please leave, sir.
Is that being taken into evidence or not?
You are violating a court order right now by not leaving.
Hold me in contempt, bro. I dare you.
By calling me bro is very disrespectful. By cussing at me and throwing things at my staff. All right, if we can have the minute entry note that the defendant has left. If the minute entry can note that on his way out, the defendant repeatedly cussed at the judge. If the minute entry could note that the defendant threw, what is that called? A flash drive towards my staff. If the minute entry could note that the court repeatedly ordered the defendant to leave after warning him that he wasn't following the rules. He failed to do so, continuing to violate a court order. I'll now continue to explain my thought process. I'll add to the credibility determinations the defendant's conduct on his way out lends to my credibility determination about him that I do not find him credible at all. The other case that supports my application of ARS 13-2921, I think is State versus Snyder. That is 2024 Westlaw 342301, and specifically paragraph 16. That case talks about the defendant posting videos, and talks about several people contacting the plaintiff about the videos posted by the defendant, and talks about holding the defendant responsible for the resulting communication of those third parties not being so extraordinary that it would be unfair. So I think that case supports my factual findings. I do think that all of these acts that I've mentioned were directed at the plaintiff. I can totally understand why she is alarmed, scared. I think not only a reasonable person would be, but I think almost any person would be. I think it'd be unreasonable not to do. I'm finding that there's no legitimate purpose for any of these acts, and in fact, I'm specifically finding that I think the defendant's purpose is specifically designed to harass and bug and annoy. And I think his conduct during this hearing has confirmed that. That said, the order that I've sent, and I'll make sure that the plaintiff gets a copy of the order that I've signed, does affirm that the defendant is to have no contact with the plaintiff, not to go near a protected location. The other orders is what I've changed. The defendant must have no direct or indirect contact with plaintiff through any form of social media. That was basically in there before. The defendant must not post or place plaintiff's contact information, including her work information, on any social media platform. Defendant must not, through social media or otherwise, directly or indirectly encourage third parties to contact plaintiff or to go to a protected location. What I'm trying to do there is balance the defendant's constitutional rights with the right of this plaintiff not to be harassed. I think I've done that. I've tried to do that. We'll just note that I was going to give the defendant an opportunity to hear those restrictions and convince me if I should do something else, put different wording in there. He has chosen not to participate anymore in the hearing, so to the extent he had any insight on that, we don't have it. We don't have the benefit of it. Ms. Walker, anything I'm missing, more of a record or findings that you want me to make?
One thing that, Your Honor, I have wondered about, just that goes to my fear of Mr. Myers, is that I don't believe he's been ordered to not have any weapons. I don't know if that's something that can be considered, but that's something that was not part of the original injunction against harassment.
I didn't hear any testimony or evidence about guns or flashing guns or anything like that. I'm reluctant to do that without that sort of.
Okay, I understand.
I hope it doesn't happen, but if it does happen, feel free to come back and ask for a modification.
Okay, thank you, Madam.
Anything else that you want to do? Any other findings that you think I should be making? If we anticipate the appellate court is wondering what I did and why.
Your Honor, I do have a question about the current videos that are still displayed on Mr. Meyer's YouTube channel that violate this. I understand that things that are outside of protect order are not considered, but he has violated this probably more than a dozen times with additional social media content. Is there any sort of consideration for him to be required to take those videos down that do display my contact information? Because unfortunately, they do continue to encourage people to reach out to me as recently as today to harass me.
I'm thinking.
Of course. Thank you.
It must be a first. I did know that I have the authority to do things that happened already from a First Amendment standpoint. I'm by no means a First Amendment scholar, or although I do dabble in it, I'm interested in it. So I don't feel comfortable doing that in past tense as opposed to going forward.
I understand. Thank you for considering.
I wish I could do more for you. I apologize.
You have nothing to be sorry for. Thank you so much for hearing me today.
And if you think there's more I can do from a constitutional standpoint, file something, file a brief, give me the cases, ask for a modification, and I will listen.
Okay.
With both ears.
Thank you, Your Honor.
Thanks, everybody. Have a good one.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service. Alright, so had some people get upset with me yesterday because I just ended that, so I guess it's better this way. We can hang out for a couple minutes and see if Prophet calls. I don't have time to, where is it? I don't have time to go over the whole thing right now, because I got shit to do. Oh shit. So I had this posted up on my community page. I don't know if Whatever. I don't know how many of you had an opportunity to read it, but it's pretty good. Alright, what's happening, folks? Move this thing over again. So, yeah, confirmed that he has been taken. But that's what we're going to go over later tonight. I don't know that I can wait for profit. Let me just reach out and touch him, see if there's anything there. Anybody have any questions about what's going on that I might be able to answer? I think Prophet recorded it until he was kicked out of the hearing, Sassy. Well, it wasn't that he was kicked out of the hearing. We're going to lose the video because he's calling.
where the police officers were going to have to go under oath and weigh the evidence and all that, suddenly and here's the most telling part, sir, and I'm waiting on the body. The arresting officer was not here. So if I wouldn't have got arrested, he wouldn't have been here. The other ones were, the witnesses were here, but not the arresting officer. See, so they can't say they didn't know when their main witness wasn't even here. And then magically, 2 days before the hearing, we get a new prosecutor who's not the wife of the person accusing me and getting me arrested. They can't say that this wasn't coordinated, especially with you, sir. You've seen it all. You've seen it all. Why was their only goal, sir, was to stop me from that hearing, from putting that cop under the witness stand, under oath, and look at the lengths they went to. I'm not going to be found guilty of the violation. I should have got due process, right? It's because it's alleged that I violated it, right? So, allegedly I violated it. They took me to jail for a civil thing that's the equivalent of missing jury duty. Literally, I wasn't a fugitive from murder. The FBI wouldn't even arrested me right there. They would have let me finish the hearing. You know what I'm saying? So for some reason, they're claiming, oh, we had nothing to do with it, when literally it involves the prosecutor's wife. And they went and got that because you wouldn't do it. You wouldn't issue the order. So they went and got Superior Court to get an injunction harassment and then said I violated it by driving past the building. Well, I drove past the building on the way here. Why aren't they here? You get what I'm saying? I drove past the building on the way to this hearing. So I'm expecting them to show up and arrest me in any minute. Do you get what I'm saying? It's hypocrisy. I can't drive down the road. And then now my evidentiary hearing, we're almost at 180 days. Look what it took me to get that evidentiary hearing. And so if this is not an evidentiary hearing, I'm filing a motion to dismiss, Rule 15 motion for sanctions. All their witnesses are going to be excluded. They missed 4 witness deadlines, sir. The one by under 15 by rule. They had to turn over their witness list by rule by the first pretrial, July 11th. They didn't. Also, I filed the disclosure request. So by 30 days from that, I filed that on June 9th. So they had till July 9th. So basically, they had to the first July 11th pretrial to provide me the witness list. They did not. We go into Cranshaw's courtroom. I say, Cranshaw, I filed a motion to compel on June. It's all in the record, sir. Motion to compel. After I kept asking them, I did the couple requests, timely thing. Now remember, I'm supposed to be incompetent too. I'm mentally ill and incompetent, but somehow I'm filing all these things in a timely manner, putting in these disclosure requests, put in the motion to compel. We go to the first pretrial. Judge Cranshaw compels them to give me the witness list by August 9th. That was on July 11th. Okay. August 9th comes and goes. I still don't have the witness list. We go to the hearing with Judge Mayhew. In the interim, after they didn't meet Cranshaw gives me the disclosure deadline. They failed to meet it. I file a motion, a Rule 15 motion. It contained the word bullshit. It got stricken. So I filed the motion to compel. Cranshaw orders it. They don't follow it. I file up by following my motion saying, hey, they didn't follow the order. It gets stricken for the word bullshit. We go to the hearing. She says, your things, we don't need to beat the dead horse from last time, but I go to the hearing. She says, your motion's being stricken. I said, for what? She kicked me out of court. Never got to put anything on the record that day. The only statement that was made on the record that day was by the state. They talked in the mic and they said, we have our witness list. We're just getting it coordinated. So they admitted on the record in Judge Mayhew's, they had their witness list. Now remember, they were already supposed to give it to me a month prior. So this is throughout the thing, I'm prompting, I'm saying, hey, I need that. Hey, I need that. I'm filing my motions. They're ignoring them. So Cranshaw gave them a deadline. They ignored it. At the August 23rd hearing, they came and said, we have our witness list. So I heard that because remember, I got kicked out of hearing. So I emailed Matt Walker for 9 straight days saying, well, you just said you had the witness list. Why don't I have it? Nothing. And all this is going to be in the Rule 15 motion that gets filed today because the sanctions are going to be all their witnesses are gone. And if you have no witnesses, you have no case. And so, if the glove don't fit, you know what I'm saying? And so here we go now. We're at your hearing when we met, sir, at the last hearing. And I'm sitting there pounding the table saying, I need you to order them to release these witnesses. Because now this is the 4th time I'm having them, the witness list, ordered to be released. The most basic concept of a criminal prosecution, the witness list. And then, so you ordered it, right? They gave it to me that day by the end of the day. And guess what they gave me? They gave me a list containing the arresting officers and the 2 victims. They could have gave me that 4 or 5 months ago. And that's the point, sir. It wasn't like they were doing this deep dive investigation, still trying to see was there witnesses that we haven't got a hold of. You know the game. They literally, this is so boilerplate, feet dragging obstructionism. That's all this is, to gain a tactical advantage. They waited 4 months to give me the witness list after I had to literally basically get myself in contempt to prove a point that I've been telling them to put the witness, and you know what they responded by? Filing a motion saying I'm mentally ill. Not saying we made mistakes in this case. We didn't follow the rules of procedure. No, this guy's incompetent. And what they're really saying, sir, is you're incompetent because they're saying you agreed with me. So if I'm incompetent, you must be incompetent, and you ordered this, and I was bound in the table saying, I need you to give an evidentiary hearing. I need you to order the witnesses. And they're saying, well, that guy's incompetent. He was in there, but somehow the judge ordered the things I was asking for, but I'm mentally ill and incompetent. While I'm sitting here saying, you got a law degree, you've been here 30 years, what's your excuse? You were supposed to turn over the disclosure, Rule 15 disclosure, by the first pretrial, and I filed a motion to compel and all this, and you want to sit over there all high and mighty. You haven't done a single thing by the book in this case. And the first day I talked to this woman, it's come full circle. She told me she's not worried. She has absolute immunity. The first day I talked to this woman back in June at my arraignment, I called and said, who's the victim? She said, I'm not, and we had a little discussion. It's all, the whole world can listen on YouTube. She tells me, I'm not worried about you. I have absolute immunity. So I knew right then, and that's why I started filing. Sir, there's a motion to compel. That right there was ordered by Judge Cranshaw, then ordered by you. There's multiple times.
All right, sorry about that. All right, it sounds like another count of felony harassment. He should be arraigned. He should be arraigned tonight at 8 or 8:30. I think Reluctant Prophet is going to go live with the arraignment hearings. If he gets bond, I'll get him bonded out. If he doesn't get bond, make sure you call that judge. Because, geez. All right, yeah, I don't know that I've got too much more to add here right now, but please, guys, make your voices heard. Yeah, scrolls go live. Yeah, I just I can't believe this is happening. We got the legal fund posted up top, guys. If you find it within your heart, and I think Sassy just posted this, but I got the link. And Lane, you know what Lane would say. Let's see if anybody knows. Let's see who's the highest ranking shareholder in the chat. Tell me, yes, this is Lane's ex that we're talking about. Shannon. Or in her mind, at least. It's in her mind. Send that stuff to, I appreciate it. I'm not going to say no or anything, but our boy needs it. What was I saying, or where was I going? Yeah, so does anybody know what Lane would say about all this? Lane would say, good. All right, guys, thanks for coming in. We'll let Prophet do the arraignment, and maybe I won't go live tonight with it, with the anti-slap. But we're going to read all 43 pages of this anti-slap. That's for sure. Just to make sure that it's on the record for the whole world to see. We're not going to let anybody get away with any of this stuff. So, all right. Love you guys. Later.